Hi, I'm attorney Matt Benedict, and today we're going to be discussing domestic relationship PPOs. Okay, in this video I'm going to first educate you on PPOs in general in Michigan, and then at the end of the video I'll give you some plain English advice for either obtaining a PPO or defending against a PPO. What is a personal protection order and/or a PPO? A PPO is a civil injunction prohibiting violent or stalking behavior by a person, and this person is called the respondent. So I also need to educate you on some of the terminology that's used, and the petitioner is the person who is prosecuting the claim or the plaintiff. They are the person seeking protection from the court, and the respondent is the defendant or the person that may end up with an order indicating that some of their behaviors have to stop. In this slide, we see the definition of a domestic relationship. A domestic relationship is what separates this form of PPO from the other types of PPO I previously mentioned. As you can see, the definition is pretty straightforward, with the exception of the last qualification, which requires that respondent and petitioner either have or have had a dating relationship. A quick comment regarding the third qualification for a domestic relationship. Recently, I represented a petitioner who was seeking protection from her 70-year-old father, and she was a woman probably in her 50s. Now, obviously, these two parties had not lived together for some time. However, just because of the relationship between the two and that at one point they had lived under the same roof, I was able to proceed under the theory of domestic relationship PPO. A couple of comments about this definition. Some fact patterns that we can consider. What would happen when the petitioner and the respondent have an online dating relationship? Perhaps they're exchanging chats late at night, that sort of thing. Certainly, the facts in that situation could very well lead to an argument that there was indeed some affectional involvement. However, that certainly is an avenue in which to defend a PPO as well, is that there was not any expectation of affectional involvement. And the second fact pattern I'd like to comment about is, what about the one-night stand? Petitioner and respondent hook up for a one-night stand, and then respondent develops a fatal attraction style obsession with the petitioner. Now, this one, I would argue that indeed a domestic relationship PPO would not be appropriate in this situation, because the facts would lack the frequency that is necessary for a proper dating relationship. That does not disqualify the petitioner from seeking other forms of a PPO, such as a purely stalking PPO. There are some exclusions to obtaining a domestic relationship PPO. Number one, parents cannot get a PPO against their children, and children cannot get a PPO against their parents. Category 3 on the screen. Basically, this means that teenagers can pursue a domestic relationship PPO. Recently, I received a phone call from a family that was having a lot of problem with their son, and he was being harassed by his ex-girlfriend. So I did inform them that one course of action that we could take would be to seek a PPO against a middle school girl. In this slide, we see the standard of proof for obtaining a PPO. What is an ex parte PPO? An ex parte PPO is an ex parte order, which means it is an order that is issued by the court without a hearing. Some practitioners would call this an emergency motion. Most PPOs are started out in an ex parte fashion. The process for obtaining a PPO is first you obtain the paperwork from the courts, or you can obtain the paperwork online. You fill out the paperwork, and you also attach an affidavit or a letter describing the respondent's conduct. And from those filings, it has to be clear to the court that the petitioner is going to experience immediate or irreparable injury. And that translates to that the petitioner is right now going through some bad experiences, and those experiences are going to continue and cause a lot of damage, a lot of harm, if the court does not act immediately. So what facts would be an example of a situation that would qualify for ex parte PPO? Number one, if the respondent has a history of domestic violence and or abusing family members, then that history, along with a current situation, would probably be enough to convince the court that without intervention, the respondent is likely to continue to harm the petitioner. What else would be a good evidence of facts that would be sufficient for an ex parte order? Second, I would say that if the petitioner made a clear expression to the respondent that they wanted the respondent to stop the behavior that's bothering them. Again, a clear pronouncement of cease and desist, along with some real current facts that show that the respondent is continuing to persist in their bad behavior, their violent behavior, or their harassing, stalking behavior. Those would be some examples of fact patterns that would be enough to establish a ex parte order. Now I will discuss the various conduct that would qualify as violent or harassing acts. This stuff is not as clear-cut as it may appear at first. There are several catch-all categories, and the PPO statute incorporates the criminal harassment statutes as well. In this slide, we start to look at some of the specific conduct that is identified in the PPO statute. And just real briefly, I'll go through some of these. Certainly entering onto a premises by itself would not qualify as something that requires a PPO. However, entering on the premises after there's been clear instruction by the the petitioner, indicating that they are not welcome yes, then that would be some ripe material for obtaining a PPO. And purchasing a firearm, that by itself would not be conduct that would require the court to take action. However, if there is an implied threat or an express threat coupled with the purchase of a firearm, then sure, that would be something worthwhile for the court to take a look at. In this slide, we are examining more examples that are cited in the statute. On the top, this would be a factual situation where, for instance, a girlfriend moves out of her boyfriend's residence and she has property that is left at the residence, and the respondent is not permitting her to pick up that property. Third example on this slide indicates that a disgruntled boyfriend, girlfriend that starts to play games with the ex's pets is expressly prohibited by the stalking statute. In this slide, we see the statutory language that really opens up fact patterns permissible to receive court supervision through a PPO. Number one indicates that the PPO statute incorporates the criminal harassment statutes and all the conduct that is articulated in those statutes. And number two is what I like to call the catch-all. And as you can see, just about any conduct that the petitioner can articulate and present to the courts that causes a reasonable apprehension of violence would be sufficient material to include in a petition for a PPO. In this slide, I have provided an excerpt of the stalking statute, and this would be the criminal stalking statute. As you can see, it is full of meaningful definitions, and the first one I think that would be important for PPO matter would be to look at number 1A, course of conduct. Under this definition, you'll see that course of conduct requires two or more non-continuous acts. The second definition that I would call your attention to would be number 1E, unconsented contact. And again, the Michigan legislature has provided some expressed conduct that they believe would qualify as unconsented contact. Now let's read through those real quickly. Following or appearing within the sight of that individual, approaching or confronting that individual in a public place or on private property, appearing at that individual's workplace or residence, entering onto or remaining on property owned, leased, or occupied by that individual, contacting that individual by telephone, sending mail or email communications to that individual. Now this last one is important because this opens the door for respondents' conduct of sending nasty text messages and or posting nasty information or comments about the petitioner on social media sites. Okay, this next slide is an excerpt of the jury instructions for criminal stalking. I included this in my presentation because it really gives the viewer a firm grasp of what needs to be proven for a stalking charge. And because the domestic relationship PPO statute incorporates anything that would be considered criminal stalking, this instruction is beneficial to anyone who is considering filing for a domestic relationship PPO. As you can see, this instruction would provide a really good starting point for any petitioner seeking a PPO in the family court based on stalking behavior. So here's some general advice for a petitioner filling out the paperwork to get a PPO. Number one, I think the petitioner should focus on the respondent's first bad act. Keep in mind that there are two theories upon which to bring a PPO. Number one would be violence has occurred or violence has been threatened, and number two would be stalking. Under the threatened violence or violence has already occurred, it is so very important to make a good case that respondent has already performed either a threat of violence or violence against the petitioner. Regarding the stalking theory, I think it's really important to show an occurrence and or a pattern of stalking. Keep in mind the definitions under the harassment stalking statutes require 2 or more occurrences. If the petitioner's PPO is based on a stalking theory, then I also believe that the jury instruction for criminal stalking is very important, and a petitioner should read that jury instruction and use it as a blueprint and or checklist for stating the necessary elements or conditions that would establish a criminal stalking case. And finally, for petitioners, it is very, very important that they demonstrate that respondent's conduct has caused the petitioner some sort of emotional distress. There are a number of ways to defend against a PPO. Some of the more common defenses include the following. Number one, petitioner's fear or apprehension of violence is unreasonable. That would more or less be an argument stating that the petitioner is overreacting or misreading the events. Number two, if a petitioner is proceeding under a stalking theory, that there isn't a pattern to the harassment or there hasn't been repeated instances of harassment. Number three, it's also possible to defend a PPO based on the interaction with respondent and the petitioner. And the way you would use this defense is you would more or less say that the interaction between the two parties was welcome, or the fact pattern doesn't establish that it was respondent's interaction with the petitioner was unwelcome.